Hey, I'm Nancy Cavey. I'm a national ERISA and individual disability attorney, and I want to welcome you to Winning Isn't Easy. In this episode, I'm going to talk about Social Security disability claims and your long-term disability claim, what you need to know in the interaction between these claims. But before I get started, I have to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association tells me I've got to say that, so I've done that. But nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. Now, I will tell you that Social Security disability claims and long-term disability claims are often intertwined, and I'm going to discuss this interaction. First thing I want to talk about is what you need to know about Social Security disability listings, why you shouldn't speak with the Social Security administrator assigned to your claim, and the three ways that your Social Security disability attorney can destroy your ERISA disability claim. Okay? Now, before we get started, let's take a quick break.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. What you need to know about Social Security disability listings. Now, getting your long-term disability benefits can be tough, but Social Security can be even tougher. And it can be hard if you don't understand what it is you have to prove, because what you have to prove is different than what you have to prove in your long-term disability case. It's sort of like getting in a car and deciding you're going to drive to New York City with no map or GPS. You might end up in New York City if you're lucky, but you probably are going to end up somewhere else. Now, let's trade luck for knowledge. I want to talk to you first about the five-step sequential evaluation that's used in every Social Security disability case. The first thing they ask is, have you been out of work for at least a year? Secondly, do you have a severe impairment? And then thirdly, at step 3, they use a book called the Listing of Impairments, or the Blue Book. And what they do is they look at your medical records to determine whether or not you have a medical condition or physical impairment, mental impairment that qualifies you for Social Security disability benefits. Now, the Blue Book has 2 sections. There's the adult listing, Part A. There's the children's section, Part B. If you have a medically determinable impairment that matches the list of impairments, you can be found disabled at step 3. Otherwise, you have to prove at step 4 that you can't go back to the lightest physically demanding or simplest job you held in the 15 years before you became disabled. And at step 5, that you're unable to do other work in the mythical, not real world, national economy in view of your age, education, skills, restrictions, and limitations. So that's 4 and 5. And quite frankly, that's where most of these cases are decided. But there are occasions in which we can meet the listing of impairments. And I think that helps in an ERISA long-term disability claim. So what's a listing of impairments? Do you remember your biology class a million years ago? When you studied biology, you studied in the form of body systems. So you learned about the cardiovascular system, the digestive system, the pulmonary system, et cetera, et cetera. The Social Security Administration takes a similar approach and classifies medical conditions under the body systems we learned in biology. So to qualify for a listing, you have to meet the symptoms and the laboratory findings for each of the listed conditions. If you do that, Social Security will find that your medical condition is severe enough to meet a listing. That can be difficult, as I tell my Social Security clients, because doctors didn't take a class in medical school to learn how to write a report for Social Security disability purposes to establish that you meet the listing. Now, let's talk about the listings, because I think it's important that you understand this. I always try to shoehorn my clients into listings, but if not, I use the listing criteria at step 4 and 5. What are the types of conditions that might qualify you for a listing? Well, cancers, cardiovascular disorders, digestive disorders, endocrine disorders, genitourinary disorders, hematological disorders, immune system disorders, mental disorders, musculoskeletal disorders, neurological disorders, respiratory disorders, skin disorders, and special sense disorders. When you open up the Blue Book, you'll see that each listing has, for each impairment, has different criteria. And what's important is that if you're going to meet the listing, you're going to see what the overview of the impairment is. You're going to see whether or not your symptoms or your diagnosis qualifies. And you're going to see what evidence, including test results and documentation, is required. That's important because, again, I think that information is also relevant in your long-term disability claim. There are some conditions that have no listings. For example, fibromyalgia has no listing. Social Security recognizes it as a significant impairment and medical condition, but there's no listing. So let's take a walk, if you will, through the Blue Book. Well, let's walk to Social Security listing 1.00, musculoskeletal disorders. Now that section of the Blue Book covers skeletal spine and upper and lower extremities that are affected by the musculoskeletal system and radiculopathies caused by disc injuries. I want you, if you have time, to Google this and look at the listing 1.00 and look for spine disorders at 1.15. You can see that this is not easy. It's pretty complex to both medically and factually establish that you meet a listing, which is why you want the help of an experienced ERISA disability attorney. Now, I will tell you, as an ERISA disability attorney, I also do Social Security disability attorney. And there are some ERISA attorneys who point blank say they don't do it. And the disability carrier might be suggesting that you use some sort of an advocate. I strongly suggest that you do not use an advocate because they're not advocating for you. If you can't find an ERISA disability attorney like myself who does Social Security also, you want to have two separate lawyers. But I'm digressing because if you don't meet a listing, you are going to have to qualify for benefits at steps 4 and 5. And you have to prove that you can't do the lightest job you held in the 15 years before you became disabled or other work in the hypothetical, mythical, not real world national economy in view of your education experience, physical or psychiatric limitations. That requires teamwork. And again, I will do things such as using an appropriate residual functional capacity form in a Social Security case and amending or attaching it to an attending physician statement form that's used in a disability claim. APS forms and disability claims don't ask the right questions, while RFC forms ask the right questions. And so because there's this overlap, I think that the evidence that can be developed in both cases are applicable to both cases and can be used in conjunction. There is, however, a caveat here. The caveat is that you heard me use the word age. At step 5, age is a factor. And in most disability policies or plans, age is not a factor, which is one of the reasons why disability carriers can thumb their nose at a Social Security decision. Let's take a break, and we're going to come back and talk about why you shouldn't be talking not only to the claims adjuster in your long-term disability case, but why you shouldn't be speaking with a Social Security Administration claims people assigned to your case. Let's take a break.